addressing the things that he has suggested you need to address, I think as taxpayers, you certainly have the ability to do that. But as your planning board this evening, the statute's fairly clear that your role is to review the report and identify any provisions of the proposed redevelopment plan which are inconsistent with the master plan and recommendations concerning these inconsistencies. Now, there certainly is a catch-all and any other matters as the board deems appropriate. I would suggest to you that that's not a catch-all for any issues. I think it's planning issues or issues of concern. And though Mike's comments notwithstanding, we do have a limited role. He certainly has a right to present his concerns to you, but I guess what I'm saying is I don't know that the planning board has a role to weigh in on either referendum or how this is being funded any more than it would for any particular homeowner saying to question what your finances were. I don't think you have that role, but.
Well, Council Kovacs, one of the points I did make was that these are two-story buildings. We are redeveloping. In other words, instead of replacing one-story structures, we're putting in place at various locations now being formed two-story structures with additional capacity, additional usage. That clearly is something the planning board can weigh in on, is it not?
Absolutely, and that was going to be my next point, Mike.
Okay.
That as to design standards, they certainly can do that, and I was going to have Mr. Robert address that as one of the other topics, but that is certainly a legitimate, as far as design standards, height, bulk requirements. I don't know that those have been designed at this point in time in Mayor and Council, and I think redevelopment ordinance specifically states that.
But they're out for bid. Clearly, the plans have been submitted.
Sir, I can only tell you what's in the redevelopment plan. Again,
This is all moving along very quickly, and all I'm basically asking my planning board to do is seek input. So once again, thank you again.
just on that comment, Mr. Robert, am I correct on page 11 that the setback height related bulk requirements shall be determined by Borough Council acting as the redevelopment entity? Is that correct?
Yes, and I guess Mike can pick me up, take a look from here. The idea is that the plan doesn't stipulate that the only option is to do a public-private partnership. Anything in this plan would not prevent the Borough Council from proceeding to do what they would normally do if there wasn't a plan, which is to proceed for a capital project, which potentially could include those pavilions. What we did do was recognize the fact that a certain amount of work had already gone into the conceptual design of two pavilions that have been referenced in the bottom ordinance, and we wanted to make sure that anything else that got developed on that boardwalk were consistent with those pavilions, so that there would be architectural consistency. So we used those architectural designs as the model for anything else, any of the other pavilions that would potentially be developed there. So it effectively, as you said, the ultimate decision is really up to the mayor and council acting as the development.
Good evening, planning board members. My name is Fred Marziano, M-A-R-Z-I-A-N-O. I live on 208 2nd Avenue. Mr. Roberts, I'd like to compliment you for a very professional presentation, very thorough and easy to understand and follow. It's one of the better ones that I've heard in a long, long time. Thank you. I would ask the planning board a couple of questions, if I may. If you feel like you don't want to answer them out loud, that's fine, but please do think of them. How many of you have read this plan, every single sentence, from front to back page? How many of you know exactly what it is you're being asked to consider and to look at here? Because if you have in fact read all of this, you know at this point that I think we can safely say we have the cart ahead of the horse. We don't know, it's not included in here, no reference to it at all, the cost that is involved with A, building, constructing all of these, like I said, we call them edifices, and B, the maintenance cost of these. We did have a very, very, very basic and elementary pro forma that but that was, trying not to be impolite, but it was, if somebody working for me gave me that, I would say, go back and have a high school student rather than an elementary school student develop it. Because putting things in there that included just the same exact insurance charges for both buildings, like $4,500, which is a fraction of what it cost me to insure my home, which is far less value and is just a block and a half away from the structure. So the numbers that are thrown in there are not even beginning to be approaching realism. The insurability, the terms of insurance, the cost of insurance are unknown. Do you want to have structures that cost many, many millions of dollars that are not insured, that we have to support ourselves? There's no reference to that in this, and maybe there's not supposed to be at this point, but you ought to be thinking about those things as you consider what you're approving or developing. You would, if you read that, you would also know that a redevelopment entity, if that redevelopment entity that's appointed or chosen chooses to do so, they can construct a building that is an additional 10 feet taller than the ones that are actually documented in this plan. And it looks like they don't even have to get approval to do so. If it's something that it looks like it's something they need for the building that they want to put there, then we can just go ahead and accept another 10 feet height. Belmar's counsel in this, according to the provisions, can convey, you know what convey means? It means to give, or lease our own town's personal property, our own property, to a redeveloper, and to do so without public support or authorization. So that is something that you have empowered the council to do if you agree with the terms that are outlined in this document. So what I'm here to ask for is, I urge you to defer consideration of this plan until more is known. I don't understand the hurry. I'm not here to say that we shouldn't do it, but I'm here to say that we don't know enough before we start deciding on these things. I urge you to defer this because it is such a major decision that's going to result, I think, in a revamping of the culture and of the financial stability of our town. We're not a huge town. We don't have a big population. We don't have a big tax base. And I know a lot has been said that all of this will be paid for by the beach utility fund, but that's still in doubt. So one of the suits that was mentioned tonight is a suit that is seeking clarification and understanding that, in fact, the beach utility fund can pay for all of those things. Because if it can't, we're all on the hook. So we just want to know once and for all, if in fact the beach utility fund can pay for all of these things, given the contemplated use for some of the structures. So with all of that, I also ask, I don't know why this town, which is a wonderful town that I love, I fell in love with it when I moved here more than a decade ago, and I lived not far from here before that. I don't understand why we can't listen to a large population in the town, and why we tend to dismiss those people as dissenters and people who, forget all the words that were used in the press to define this. But we're just trying to get a vote by the people who are going to have to live with this and have to end up paying the monumental cost of all this on an ongoing basis. What's wrong with having the people vote on something of this huge, long-term magnitude? Thank you.
Good evening. Gene Kramer, Worth Avenue. And I actually have a question. Sir, are you the author
Yes.
of this? Oh, that's great. Ask the author a question. On page 21, under permits and approval, I'll read it. Redevelopment of the redevelopment parcels identified as redevelopment plan will be subject to coastal area facility review act, CAFRA, approval by the New Jersey Department of Environmental Protection. I guess my question here is, what would be the benefit of getting CAFRA permits for each of these pavilions or redevelopment parcels?
Again, I'll basically just speak from here, but then that was a provision that was added to the plan anticipating the possibility that there could be a public-private partnership. As Mayor explained before, the actual redevelopment of the footprints, as long as those footprints stay consistent with footprints that were in place pre-Sandy, the borough would not need CAFRA approval. But we did not want to assume that a redeveloper would not need CAFRA approval if there was a joint public-private partnership. So the reason for that language in the plan was really just to put any potential developer that might be thinking about making a proposal and looks at the plan, thinking that they would not have to worry about CAFRA. The worst case scenario is they would need to confirm with CAFRA whether or not a permit is required. But certainly, anything a private developer would do on the private developer that the borough would hold them responsible for would need to include any permits and approvals that from any agency, whether it's CAFRA or any other agency that they would need ordinarily need to get. We didn't want them to think that they were exempt from it.
Thank you. And I agree with that 100%. However, right now, we have the mayor's conversation with, apparently, with the Commissioner of the Department of Environmental Protection. We don't have anything in writing. Am I correct, Mayor?
There is something, I don't have it on me right now, but yeah, I mean, when I talked to him, it was probably, I remember I was at the Busy Bee Laundromat when we were getting electricity, so maybe 5 to 7 days after the event, because we were starting to tear everything down, because our engineers prepared unsafe structures. So I called him and I said, listen, I know we're already started doing this, but just to be clear, we'll be able to rebuild what was pre-existing without any permits, correct? And he said yes. I think the only thing we had to get a permit for, I could be wrong on this, was we did an extra 1/10 of a mile of the boardwalk that wasn't there before. So we had to get CAFRA approval for that. But for the pavilions that were there on October 28, 2012, on those same size footprints, we were okay putting back without DEP approval or CAFRA permit. If we added something else, if we attempted to do what Councilman Gillen mentioned before, not that he's suggesting it, but that if someone said, hey, listen, what about building new ones or putting back things that were there 40 or 20-something years ago, we could try that, but in that case, we would need CAFRA approval. And they already told me, not in writing, but you're not going to get it, so don't even ask for it.
By the way, my real question is, what are the actual benefits of the permit itself? In other words, and I was able to come up with two real easy. First benefit would be that the CAFRA permit would be issued by the NJDEP. And in New Jersey, as you're aware, Mayor, the NJDEP adopted public access rules, notwithstanding Sandy, but they went into effect last fall. So the NJDEP is actually the trustee of the public trust doctrine. Don't you think it would be better if we got a permit that we expect to pass on the financing for, and have bathing privileges pay for that? In other words, wouldn't we be in a better negotiating position if we had a permit from NJDEP and giving them full disclosure as to how this building is going to be paid for? The second, I have another benefit that I saw from the permit process, and I don't know of any other way to get it. It's a federal consistency certification. In New Jersey, if you want, in the coastal zone, if you want federal consistency certification, the way that you get it is you get a permit from the NJDEP. Now, federal consistency certification would also put us in a better position in negotiating with FEMA to get perhaps some federal money to pay for some of these buildings. If we move forward with nothing more than a waiver, then we don't get these things. In other words, we still have the potential battle of somebody intervening and saying that we shouldn't be charging each users for paying for a building. We also have the federal consistency. I know that, and I did read the Commissioner's Administrative Order. As of October 29th, and it seems to be selected right before Election Day, all municipalities have to true up as to what they've constructed and what they propose to construct. And then the Department of Environmental Protection will tell you whether you need a permit or not. Don't you think we should handle these things straight out beforehand?
Well, I would argue, I think you're handling them straight out, but I would also tell you.
Why don't we apply for a permit then, Mayor?
Well, I would tell you that it's not required. I understand you think there's some advantages to it.
I think there's two distinct benefits.
I don't think those benefits outweigh.
Is this the reason for expediency of why we want to start? You know, we're going to get into a situation here now where we start construction and then it's going to be a forgive me when the DEP informs us that permits are actually necessary?
No, that situation will not occur.
Can we please then get a jurisdictional determination from the DEP saying that they have no jurisdiction? That's a one-page application there.
I don't know.
I just don't know that that's an appropriate topic for this meeting at this point in time, given the limited jurisdiction and the fact that this is a special meeting limited to this topic. Again, I just caution the board, this is a special meeting, this isn't a regular meeting, we're limited as to the topics that we can discuss. Mr. Kramer's points notwithstanding, I don't know that because of what we're looking at, as opposed to getting the federal consistency certification, that's consistent with what our role is here this evening in our special meeting.
Excuse me, sir, the plan in front of me does say, will be subject to Coastal Area Facility Review Act approval. If you want to take that out, then take it out.
No, I'm not going to take that, but I guess what I'm suggesting to you is that's not inconsistent with the master plan or reexamination. You're now asking the mayor, will you apply for that certification, which goes beyond the redevelopment plan.
Sorry, you've been very patient.
Yes, thank you. My name is Brendan Reed, 109th Avenue. How about three questions? First, Councilman McGovern brought the point about the 19th Avenue site. Is there a vision or process in this to say allow for the redevelopment, say for what happened at the 13th Avenue for the destroyment of the McDonald's, the Matisse, for that to be moved, say back to the 19th Avenue site? Would this be allowed under the redevelopment? Because, you know, I've had some discussions with my neighbors, said, all right, because given what was pointed out, which was, you know, with the changes in use, with the development of the homes along that stretch of Ocean Avenue, that, say, having a simple commercial building may not be as attractive, but say, but at the 19th Avenue site, because of DJs and other buildings, that may be more viable. So I'm just curious to know whether or not the redevelopment plan would allow for that, you know, if that was to be commercially viable.
I think that in this case, my answer would be that the best course of action in that regard, if at some point there was a consensus that was the location that it should go to, is that the parcel descriptions in this plan would need to be amended. And that's why I try to point out that at this point, we try to anticipate that pavilions are going to go somewhere close to where they were. But if the borough determines there's a better location along that stretch that's covered by this, the other thing that I have to point out is that I am not clear, I guess the 19th Avenue would be within lot 3, but I know that the entire boardwalk is not necessarily covered by this redevelopment plan. So that would be my first point. But if the borough council decided that was the best place for, say, the 13th Avenue pavilion to go, this plan would have to be amended to show that.
Okay. The second question I have is, whether the redevelopment plan would allow for, instead of, say, a pavilion at 13th Avenue, say, for an open pavilion, a gazebo type structure? That's my second question.
Well, I guess, again, if that, based on the current circumstances, which is our understanding that the pre-existing footprints would be replaced without permit, anything beyond that would require a capital permit, and that's whether it's privately developed through a public-private partnership or by the borough. A couple of scenarios. One is that one of those footprints could potentially be an open building. If there's no dictated, there's nothing in the plan that would require it to be enclosed. So you could have some kind of a building like that within that same footprint.
Yeah, because I was reading that FEMA would say would look openly favored at, an open structure as and so a case could be made that given the needs in our community and given that location, it may be more acceptable to a commercial use. And my last question is there a provision in the redevelopment plan, say for an RFEI process, of course, just to see whether or not any type of future public-private partnerships along the waterfront, along the boardwalk will be financially viable? And I'll give an example. Say at the 8th Avenue site. So I mean, just came up in discussions over beachfront redevelopment, a big debate over whether or not that mini golf, at the 8th Avenue site. And there was I wouldn't mind. I live right across the street from it, so it wouldn't bother me so much. But there was a considerable debate and discussion, consensus. It's not maybe a good idea for that, but potentially another potential use for that site could be, say, a family restaurant, which would be complementary to the existing businesses. But before that could even take place, I don't know whether is there a provision to see whether or not there's even a commercial viability of that, whether it's a process where you can put out an RFEI to see whether or not there would be any interest whatsoever by any developers based on the seasonality, based on the potential economics.
Well, again, I guess the short answer to that is absolutely. The beauty of this process is that there's a lot of flexibility that the redevelopment entity has, mayor and council has in entertaining interest. And whether it's an RFQ, an RFP, or just a request for a letter of interest in a particular parcel, this plan would then give them the option to do that. Just the difference, and just to kind of correct a statement that was made earlier, the plan does not allow the governing body to entertain something without public authorization. Public authorization comes from the redevelopment. What it does do, though, is that if you're going to take this process and you're going to put out an RF, whether it's a letter of interest or request for qualifications or whatever, the difference between this and just selling off excess property to the highest bidder is that you get qualifications back and you select the right developer for that project. And it's not necessarily the highest bidder. Sometimes the highest bidder doesn't know any better, and they're not the person that's going to successfully build a project. And many times the RFQ will require that the proposer provide their financial security, their experience, their ability to get financing and all that. So that's how the borough council picks the right partner, and it's the partner that, for example, the 9th Avenue Pavilion, that was Chefs International, that's what they do restaurants. So they know how to finance them, they know how to staff them. So presumably a similar process, and absolutely, I turned the short answer to a very long answer, but the answer is yes.
Like with the new restaurant going in the building.
Correct.
Thank you.
Thanks, John. Anyone else? Yes, sir. Way in the back.
Good evening, Bill McKim, 905 Ocean Avenue. Two quick questions. Has the planning board formally or informally entertained ideas on 8th or 13th as to private developers for it?
Neither, I think, is the answer.
Great. So the last point is really just a general point. I don't think anybody's brought this up. What would worry me is somebody who lives right across the street from a possibility of an 8th to 9th building, but we don't know what it's going to be yet, would be, could somebody sue their way into being the next, let's not use names of our friends in Ocean County, but let's just say Secrets in Maryland, which does $35 million on the ocean front. And they say, hey, Monmouth County's going to open, let's just sue our way in and get that pavilion space. Are we leaving ourselves open to somebody who comes in with considerable money and could just sue their way into 8th Avenue Pavilion and just say, we will outlast you. You can undertake this, or, you left us this opening, and we're gonna put a $10–20 million ocean front that would really change, the possibility of what we would be looking at as a town. So I'm just hoping that you guys have those loopholes closed up so that whoever does get it is more along the line of a Chefs International. And it's not town management group coming in and saying, look at this beautiful beachfront, and we will get it, and you guys will not be able to outlast us in court. And that's just something that I think is important to make sure that that you guys really have that tied up.
Yeah, I
That
think
would be
that
embarrassing.
the best way I can answer that is to point to the statute. Because that's we can only do what the statute allows us to do. And just to give you just to hone in on that one particular question, Section 8 of the statute has to do with the powers that go to a redevelopment entity once they adopt a plan. Section 9 and Section 7 is the plan. Section 9 is the redevelopment agreement. So effectively, you cannot, no matter how much money you have, you cannot force a redevelopment agreement on the other party that the other party refuses to sign, especially if it's a use that's not permitted in the plan, because the statute says that one of the mandatory requirements of that agreement must be that the uses must be consistent with the redevelopment. So
But what if you came in as a similar restaurant? In other words, you wouldn't be able to see, a difference.
Well, again, the redevelopment plan has very specific, that's why the redevelopment plan is very careful to say that the actual boundaries would be established at the time of the redevelopment agreement. So the mayor and council control that. Effectively, this represents one more layer of control beyond what they already have, because they right now don't have to use the redevelopment plan. They can effectively consider each one of these parcels as a capital project and fund them however they can fund them. It gives them the additional option of going that route. So if they chose to go that route, this gives them the extra, between the statute, the plan, and the agreement, 3 layers of legal protection to prevent what you're suggesting.
Okay.
Is there also something a little bit different than the average, because the borough already owns this?
Right.
It's an addition.
Okay.
It's like it would be like if someone said that they were going to build a skyscraper on your property without your permission.
Okay. All right, thank you.
Thanks, Bill. Yes, sir.
Good evening, David Schneck, 302 C Street. Sorry? SCHNEC.
Thank you.
Well, obviously, the Fifth Avenue and 10th Avenue pavilions would be subject to a property tax, but if we entered into a public-private arrangement for the other 2 lots, and they built the properties, they would own the actual buildings, right?
Well, again, that would be subject to the agreement. That's a great question, because if whatever this private entity is going to come in, and that's why the agreement's so important. You're eventually, assuming they're going to build the property, they're going to build the building at their expense.
Right.
They're also going to have, that building's going to be sitting on borough property. Whether it's a long-term lease or whether it's some other financial compensation even if it's not an actual tax, it might be a payment in lieu of tax, which the redevelopment area designation allows. That's where you get into the number crunching and where the lawyers really earn their keep, because it gets that, those agreements are very sophisticated, but the basic response to your question is, there's going to be compensation to the borough for the right to be out in that location, even if that developer built the building at their expense. And that all will be negotiated based on how much value that developer thinks they're gonna get out of that by operating their business in that location.
Well, people build their houses at their own expense, and
Right.
they still have to pay property
Right.
tax aside on
This
the
is-
improvement.
It just may
on
not
the
be a
land.
property tax, it may be a different type of compensation, but there would be compensation to the borough, that would be negotiated.
I see, because generally, these redevelopment laws are used to return disused properties that used to pay property tax back onto the tax rolls, isn't that true?
Sometimes. I think the redevelopment laws have been, from everything from development of brownfields to a lot of other things, they've been expanded over time, and specifically now to redevelop not just a blighted area, but an area destroyed by
What
storm.
was the main purpose when they really came up with these laws, was to take these areas that were blighted, and not necessarily by hurricane or fire, but just by
I would
urban
refer
decay or...
to Mr. Robert, who has probably a better handle on the history about these.
And it's true that but I would say that the redevelopment statute that exists today is not the urban renewal law. The urban renewal law was based on acquiring by eminent domain entire neighborhoods and clearing them and trying to build something new. The redevelopment statute is specifically trying to remedy that approach. And there is no one way of redeveloping. There's 565 municipalities that are all very different. They all have different issues. In some cases, especially in cases in urban neighborhoods, for example, you're going to have a combination of public and private land that gets redeveloped. So that's why, for example, in the what's called the C criteria, which is section 5C of the statute, it talks about land that is owned by municipality, above Board of Education, housing authority, et cetera, and/or land that's vacant for 10 years or more that's privately owned, that by reason of its remoteness, et cetera, cannot be developed through the instrumentality of private capital. So the statute criteria anticipated that there would be both public and private properties potentially involved in redevelopment.
Right, well, the beachfront certainly gets a lot of visitors, it doesn't need a redevelopment plan to attract people to that neighborhood.
But it's
right?
it was clearly destroyed by the worst storm that we've ever seen.
Yeah, but it's not stopping people from coming, people are still coming.
They're coming because the borough built.
Well, people come, they go to the beach, I've never heard anyone say, hey, it's a nice day, let's go to the boardwalk, it's the beach, that's the attraction.
I think it's the entire beachfront, personally.
Well, people go to Island Beach State Park, that doesn't even have a
That's true.
boardwalk. Now, if a private developer builds a building there, I assume it's gonna, the cost of the building to them, they're not gonna build some cheap little building, it's gonna be like a multi-million-dollar building, I would assume, right?
I have no idea, but I'm sure that the mayor and council will be looking very carefully at what they're proposing to build.
Yeah, I'm just wondering, because the place, would have to be pretty profitable to justify, that kind of expense, and I'm just worried that there's gonna be, they're not gonna wanna do it without a liquor license, because a liquor license really is what makes a place much more profitable, restaurants all want liquor licenses,
Might be right.
it really adds a lot to the profitability, and I'm just worried that that's gonna be put
Again,
in there as a carrot, to really get the bids up and make it worthwhile to them,
You might be right, but the liquor license is a completely different set of circumstances that it's controlled by the mayor and council as well. So how many there are, where they're located, et cetera, how many are available, so.
Well, the first thing you need is a building, and so, so if they're gonna build a big building, they're gonna probably want a liquor license, at least that's what I fear. Now, about the buildings that we're gonna build, we may end up building all four, but the two that are certainly ones that you're planning to build, the borough's planning to build, Fifth Avenue and 10th Avenue. if we were to start, this is still, there's still a legal question as to whether the badge revenues can be used to finance this. As you know, former Mayor Pringle is seeking clarification from the state on that issue. And we wouldn't actually start groundbreaking until that issue has been completely clarified. Isn't that the case?
That's not a matter for the planning board's jurisdiction in this instance, at this hearing, or this limited hearing. Planning board doesn't build anything.
Okay, well, I just would think it would be catastrophic if we actually started building and then the state ruled that we couldn't use badge revenue for it, and we would put us in the lurch. And just one last comment is, I've been hearing, reading in the paper, but today in the patch, that the people that are just asking questions about this and maybe skeptical of its viability and of its benefit to the town are against recovery. And I have not met one person, not one person, who would object to just replacing what was there before the storm, bring it up to 2013 code. And there's nobody here that, I have not met one person, and all the people I talk to, that have any objection to replacing what we lost in the storm. Really what we're proposing here is to change the beachfront area into an entertainment venue. It's changing the whole nature, the whole character of the beachfront, and really that's where the objection comes in from a lot of people. I just wanted to say that. Thank you very much.
Anyone else? Okay, seeing no one, I'm going to close the public portion of the meeting. I'm going to open this up to board comments. Mr. Meyer, sorry.
Now, just certain things, more comments, again, because I have admonished members of the public, I don't need to do that, but again, our role in this instance, as and I like the board comments that the part is saying, is to address any inconsistencies that planning board members have. Again, prior to the adoption of the redevelopment plan, our role sort of as the planning expert, limited to planning issues, shall include the identification of any provision in the proposed redevelopment plan which are inconsistent with the master plan recommendations concerning those inconsistencies, and again, any other matters as the board deems appropriate. Again, I think that it's not just general catch-all language, it's language referencing our role as a planning entity. The next step, I would ask for your authorization, once we have comments, to sort of come to a consensus as to any inconsistencies or matters that should be brought to Mayor and Council's attention, and then direct me to prepare that report for your review, and then we will transmit that to the board in the normal course within that 45-day period. There was a comment concerning the floor to defer. Again, I will note that portion of the statute. Failure of the planning board to transmit its report within 45 days shall relieve the governing body from any requirement, in a sense, to listen to any direction we may have to provide to them. So that, considering that, certainly that's something you can consider to remain silent, but if you do so, the mayor and council have no benefit of hearing your concerns or recommendations. And in fact, if after 45 days passes, you may no longer have to listen to those. Not as a spiteful matter, but just to move things along. Thank you.
Mr. Meyer?
Well, with respect to what we were brought here to do tonight, I don't see additional inconsistencies with the master plan. I would hope that the governing body takes into consideration public comment and perception.
Okay.
I appreciate all the points that were raised by the members of the public tonight. I will certainly keep them in mind as we move forward, and I would like to echo the comments that I do hope the borough council and the mayor consider the points that were raised tonight.
Mr. Campbell?
Now, again, excuse me, based on our limited role, I have no issues. I do want to bring up Mr. Seebeck's comment, because I was going to bring up the same thing Doug said in reading this. If we do defer it, we literally take us out of the picture, and I do not suggest that we do that. I would like to remain a voice come in the future.
Mayor?
I just want to thank the board members for holding this meeting, especially this week. I know that this time is valuable. So
council meetings where we hear a lot of the same misinformation as we heard tonight. I'm not gonna address any of it now. The one thing I do want to say is, we did talk to our insurance broker about the insurance coverage. It's not as bad as we thought it'd be, and I think that's a good thing.
Mr. McGovern.
Master plan, I believe the pavilions are consistent with the master plan, because I consider the pavilions part of the beachfront. It's true that people lived here year-round, even when we were Howell Township, and we seeded, we became Wall Township. But it wasn't until we developed the beachfront, until tourism. Belmar developed because of the beach, not because of the people who lived here. And we developed the beachfront with the boardwalk and the pavilions. I remember when 10th Avenue Pavilion burned down. I was recreation director. That got, we delayed, we missed one summer with our concerts. The commissioners back then rebuilt it very quickly. It did not go to referendum. They did not have the meetings we're having now. They rebuilt that pavilion. Cost of the pavilion, because I was directed to rent it out outside the seasons. The cost of running that pavilion, which was uninsulated, wasn't built as a winter building. $50 for the first 2 hours, $10 each additional hour. So it costs you $100 to rent the pavilion. For all that, I think we got smarter with that. I think Mr. Campbell can probably tell you what we charge now. That building will pay for itself. This year, the 10th Avenue Pavilion, the value of the 10th Avenue Pavilion is, with that tower, is on either side of Labor Day and Memorial Day for the safety of the swimmers. When you have a skeleton crew, when the lifeguards, where college students have gone back to college, when the teachers have gone back to school, and you only have a few people there, they can see the entire beachfront, and then get on the machine and ride down there and make rescues at 2nd Avenue on 18th Avenue. Very valuable. We are not doing anything that is inconsistent with the enhancement of the Belmar community. It makes Belmar a better place to have these 2 pavilions on our boardwalk. I think that master plan is in total agreement with these pavilions.
Okay.
What we had on the boardwalk before, I don't think we had any complaints. Nobody complained of what we had. And here we have an opportunity to make it better than it was. And all we're doing is recommending to the council to do their job. And everything that was said here tonight, I go to all the council meetings, everything is coming out in the open, the newspapers printed, everything that was said here, plus. So I think that the council has enough information, and I rely on them to make a decision for us.
Mr. Hoffman.
What we're doing, I see that the plan, the proposal that was presented tonight seems to meet that requirement. Many of the comments that I heard and so forth are very appropriate, but which should be directed to the mayor and council, the governing body, who will complete this plan and the details of it.
Thank you. I have to agree with Mr. Campbell. I do believe our role here is limited. I do believe that the boardwalk redevelopment plan is consistent with the master plan. I would like to see those changes incorporated that were brought out by Mr. Roberts on page 5, the first paragraph, and also those that were discussed regarding the inclusion of the specialty shops that would include a bicycle shop, rentals, public parking, and loading and unloading areas in the new pavilions. Most of all, though, I would like to see it reflected in the report to the mayor and council, the comments made by the public tonight, mainly concerning the height of the buildings and the public-private partnerships. And with that said, I'd like to make a motion to direct the planning board attorney to prepare a report to the mayor and council. I'll second.
I'll second.
Mr. Meyer?
Yes.
Ms. Sheridan? Yes. Mr. Kimball?
Yes.
Mr. Lindes?
Yes.
Mr. Dougherty?
Yes.
Mr. McGovern?
Yes.
Mr. Kay?
Yes.
Mr. Humphrey?
Yeah.
Any other business before the board?
Yeah,
I have nothing
have a motion for adjournment?
I'll make it.
All in favor?
Aye.